The third and fourth category of protected areas is conservation and community reserve. And originally this idea was not in the Wildlife Protection Act 1972, and this was later on included through 2002 amendment, which came into force in 2003. The purpose of this is, the idea of sanctuaries and national park focuses on the natural habitat per se, and that means what happened to the adjacent areas. And this came, this idea of conservation and community reserve was adopted because of the realization that there are several adjacent areas that are also so critical for the conservation of wildlife within the national park or a sanctuary. That means this idea of corridors where wildlife quite often moves. So the moment they are outside the wildlife sanctuary or national park, they may face some kind of problems, or they may face they may be unsafe outside those protected areas. So this was probably the idea behind this introduction of this conservation and community reserve. That means the purpose was to cover areas adjacent to national parks and sanctuaries, to cover areas that links different protected areas. So that means the second seems to address this issue of protection of wildlife corridors. That means the corridors through which the wildlife moves from one protected area to another protected area. Then who has the power to determine this conservation and community reserve? It is, Wildlife Protection Act 1972 vests the state government with this power to declare conservation and community reserve. And the act also envisages the institutional mechanism for conservation and community reserves, that is Community Reserve Management Committee and Community Conservation Reserve Management Committee. That means a management committee for both conservation and community reserve. And again, this committee will be established by the state government, and the major purpose of these committees is to, or major function of this committee is to aid and advise the chief wildlife warden as far as his management and conservation of these reserves are concerned. But what is the difference between this community reserve and the conservation reserve? Conservation reserve is the idea if a particular adjacent place belongs to the government, and then that will be considered as conservation reserve. If it is a private land or a community land, then that will be termed as community reserve. And the major difference is, while the government can decide whether it wants to declare a particular land which is adjacent to a national park or sanctuary as a conservation reserve, it might face some problem if it is a private land or a community land. So the idea is, if it is a private land or community land, then the idea or the proposal has to come from that that particular private person or a community. And also the government that means the government needs permission from the community or the private individuals to declare or determine a particular area as a community reserve. So if you just look at some latest statistics, like what happened to this community reserve and conservation reserve, as on 2014, there are total 56 conservation reserves, whereas there's only 4 community reserves. So that seems to indicate that this idea of community reserve is very difficult to implement, probably because it requires permission or consent from private or community land. And all these 4 community reserves were notified in 2007. So that means since 2007 there has not been any new community reserves, whereas conservationist reserve concern, it shows that the statistics shows some kind of consistent increase in number of conservation reserves. Now let's briefly look at this institutional mechanism as designed under the Wildlife Protection Act. There are a couple of institutional mechanisms designed under the Act. The most important one is probably, in addition to Chief Wildlife Warden and National Board for Wildlife and State Board for Wildlife, there is this institution called National Wildlife Crime Control Bureau. This was established in 2007, and its major function is to address the issue of crime or wildlife crimes. And its major function is advisory in nature. It collects and collates data relating to wildlife crimes, and it passes this data to the central government as well as the state government. So the idea is to provide statistics and knowledge as far as wildlife crime is concerned, so that the central government as well as the state government can take appropriate actions. Another major institution is Central Zoo Authority, and as we had already mentioned, because zoo is another major reason, determination or notification of zoo or maintenance of zoo is another major measure through which wildlife protection has been envisaged, or wildlife conservation has been envisaged under the statute. That is, this Central Zoo Authority was established in 1992 under Chapter 4A of the Wildlife Protection Act. The major purpose of this zoo authority is to recognize or de-recognize a zoo. That means it can recognize as well as de-recognize a zoo according to the standards and facilities available in a zoo. It can also lay down standards for keeping animals in a zoo. So that means the major powers, the regulatory powers as far as zoo is concerned, is vested with Central Zoo Authority. Another major major institution is the National Tiger Conservation Authority. This was established in 2006 under Section 38O of the Wildlife Protection Act. As you can see, this is this is a species specific authority, that is, it meant for conservation of tigers in India. So this could be partly because tiger is the national animal, or maybe the sustenance or a healthy tiger population in a habitat perhaps that shows the overall health of that wildlife habitat or other wildlife in that particular habitat. What could be the whatever may be the reasons, this authority specifically looks at tiger conservation in India. Another major contribution as far as Wildlife Protection Act or wildlife protection law in India is role of the judiciary. Judiciary has been playing significant role, significant role as far as this development of jurisprudence on wildlife protection laws in India is concerned. For example, there are quite a few important case laws that discusses either the scope or whether hunting can be allowed or not, or whether what kind of activities can be permitted in a natural habitat such as a national park or a sanctuary. So there are quite a few cases, but our purpose is not to discuss all those cases, or it's not possible to prepare an exhaustive list of all those cases that deals with. But what we are doing right now is to discuss some of the important cases and that contributed, so that it becomes an illustration like what kind of roles have been played by the judiciary, and that's also an indication that what kind of roles a judiciary can play in the development of wildlife jurisprudence in India. And one of the important case law, one of the important area where the judiciary has played an important role is appointment of Chief Wildlife Warden. Even though it was mentioned in the 1972 Act, many state governments did not appoint Chief Wildlife Warden, and that happened to be a major reason, because Chief Wildlife Warden is entrusted with several key functions under the 1972 Act. So if wildlife warden has not been appointed, the whole regulatory measures envisaged under the 1972 Act that affect. So in the Center for Environmental Law, this WWF case in 1997, the court issued a strong direction to all state governments to appoint Chief Wildlife Warden. Apparently, this intervention by the judiciary brought about significant results as far as this appointment of Chief Wildlife Warden is concerned. Another major role played by the judiciary was as far as the implementation of this 1972 Act is concerned. For example, again in WWF, this is the second case in 1992, the court identified there is a loophole in the implementation mechanism and directed the government to provide modern arms and ammunition or communication facilities to forest guards. And and this we can see that judiciary is slowly stepping into the area of executives and deciding or determining what actions are necessary for the proper implementation of the 1972 Act. In the same case, the court also directed to take steps for immunization of animals around protected areas. This was based upon the realization that there could be some kind of interaction between wildlife within the protected areas and wildlife outside the protected areas, or if we do not address wildlife outside protection areas, that then it is possible that wildlife within the protected area could contract some diseases from other animals. So this was the context in which the court directed to take steps for immunization of animals outside the protected areas. Another controversial issue where judiciary had to face, or judiciary provided significantly or played significant role, is in the case of trade in wildlife. And the major issue in this context was, I mean, wildlife protection versus freedom of trade, because as we had already mentioned, I mean, trading in wildlife is a lucrative business, and this was identified as one of the major reasons why wildlife is facing extinction. And this happened, I mean, this case came when it came up before the Delhi High Court in 1994. The court categorically stated that, I mean, trade and business at the cost of disrupting life forms and ecology can't be allowed. That means the implication of this case is that, I mean, freedom of trade as envisaged or guaranteed under the constitution can't be cited as a justification for conducting trade in wildlife, or at least trade in those wildlife which are listed or which are protected under the Wildlife Protection Act 1972. Another controversial issue in the context of wildlife is tribals and tribals, I mean, wildlife protection on the one hand, and tribals and their livelihood on the other hand. This issue was raised in a case, Animal and Environment Legal Defense Fund case. They were decided by the Supreme Court in 1998, and this came up before the court regarding the permission of or granting of fishing permits in a reservoir within a national park. And in this case, I mean, the court approved the granting of fishing permits to tribals, but however, the court also noticed that, I mean, this has to be managed with strong, I mean, this has to be strictly controlled as far as, because any sort of human intervention, I mean, according to the Supreme Court's perception was that any sort of human intervention in a protected area could be dangerous to the wildlife. So in that case, court also observed that ideally the government should have provided livelihood mechanism for all those tribals in a different area, not in a protected area. So the implication is that the hint from this case is that, I mean, if possible, there can't be any kind of human intervention in a protected areas. So there are quite a number of other cases where the judiciary has placed, but the major, I mean, to sum up, the major issues and challenges that in the context of wildlife protection is, again, I mean, to what extent we can balance wildlife protection on the one hand and the tribals and forest dwellers on the other hand. And another major issue highlighted, including in a government report, is, I mean, how we can design and determine protected areas according to the ecological boundaries. I mean, that means to avoid artificial administrative boundaries. And again, another major issue is relating to tribals and forest dwellers rights, is that how we can settle the customary rights of forest dwellers and tribals while we protect or designate particular areas as natural habitats and insulate those areas from tribals who has been living in this habitat for from time immemorial. Thank you.